Welcome. Welcome again to A Taste of Justice. I'm Professor Angela May Kupenda. For informational purposes only, I am Professor of Law at Mississippi College School of Law. I've taught in the law school and other law schools and business schools for about 30 years now. But all views, all interpretations that I express here are my own and are not to be ascribed to my school. This semester, I am teaching constitutional law again. And I am, well, I said again, I usually teach constitutional law. What I'm doing this semester is I'm recording some what I call short video clips. I'm trying to stay at 10 minutes. They may run a little over 10 minutes for my students. If you want to know more about the topics, the constitutional law topics we are discussing here, at the bottom in the text box, I give you the names of the cases, and I also give you a link to any longer video I've done that can tell you more about it. Our topic for today is race and the Constitution, a very important topic in constitutional law and in our society today. A lot of it is based on the Equal Protection Clause that we will mention a little later. What I want to do here today, and it will serve as maybe a bit of a review or an initial look at the topic for my students. I just want to make 12 little points, and I hope I move through them quickly. And again, you can look at the text below to find the cases, and you can check me on my interpretations, okay? Now, as you probably know from watching the earlier clips, I love the preamble of the Constitution. Point one, the preamble of our Constitution, it shines hope on how we can move toward greater justice. The preamble says, we the people of the United States, in order to establish justice. Learning is a path to that freedom and enlightenment and justice. But the second point is that although the preamble of the Constitution says, we the people, at the time the original Constitution was drafted, people like me were not included in we the people. And not only were Black people and non-whites not included in we the people, white women also did not have full rights under the initial Constitution, nor really poor people or people who were not property owners. Still, I love the preamble because it gives us something to aspire to, for sure. But we also must deal with the reality that at the time the Constitution was drafted, in its original text, it did not include all the people. My third point is that the original text of the Constitution, another thing about it is that in a number of provisions of the Constitution, you can read about it, you can read or listen to the longer clip, but in a number of provisions, the Constitution itself actually supported the institution of slavery and supported slaveholders. Now, although those provisions were there to protect the property interests of slaveholders in holding people like me as slaves, the constitutional text itself never uses the word slaves and never uses the term slavery. And I just find that fascinating, while at the same time, the provisions, as discussed in the longer clip, clearly lend support to the institution of slavery itself. Now, my fourth point. Even the US Supreme Court lended support to the institution of slavery. The case that you will want to read later is called Dred Scott versus Sanford. And that case, some say it ushered in the Civil War. Because of the holding of that case, the United States would no longer be part slave and part free, but it kind of suggested that slavery could exist throughout the country, as slaveholders could go into free territories if they believed their property, their slave, was there trying to live as free. Now, Dred Scott also, that case said something else quite interesting. It decided the matter using, saying that the court did not have jurisdiction over the matter because there was no diversity of citizenship, because the slave was not a citizen. The court goes on to say, and well, to suggest that regardless of whether Black people were slave or free, they were not citizens in the United States and did not have rights that the white man had to respect. Now, you can hear more about that in the longer clip. Now, my point 5. So after the Civil War, we know about the Emancipation Proclamation. We've talked about the 13, 14, 15 amendments, the Reconstruction Amendments. But even after that, the court took a stance in a number of cases that I would say hindered our progress as a country in terms of all of us having full equality and operating as one. I'll give you an example, Plessy versus Ferguson. Plessy versus Ferguson, Plessy was 7/8 white and 1/8 Black. But the court said, if they don't want you to sit in a white car, you won't sit there. That you have no constitutional right to sit in the white car. And Plessy versus Ferguson is known for ushering in the concept called separate and equal. But if you look at some of the film clips like Eyes on the Prize and things like that, or any historical documentaries about race in America, you know those water fountains and schools and things were not exactly equal. But Plessy said separate and equal was constitutional. Now, there are some other cases that are discussed in the longer clip, for example, like Karmatsu, where Japanese American citizens were removed from their homes and told they had to go to internment camps because people were afraid they were disloyal to the United States. Now, these were citizens, and the court later said there was no evidence. Later, the court said there was no evidence of disloyalty. The court said that it was misled. One of the federal courts made that holding in reversing the conviction of Karmatsu many years later. But anyway, in Karmatsu, the court made a really interesting point. the court said that citizenship has both benefits, but it also has responsibilities or costs. And it said that the Japanese American citizens had to pay the price so that other people could feel safe. That's a very interesting point. And I'm sure some of my students will use that as a take for their position statements they are working on. Now let's go on to my next point, point 6. You know, when I really became aware of racial equality in the United States as a little girl, and especially after Brown versus Board of Education, I was really troubled and really amazed. You know, I would think about my parents, and look, I asked a lot of questions when I was a girl, well, I still do, but I was thinking about they were paying their tax dollars, but their tax dollars were used to fund the schools the white children could go to, more so than the schools that I was required to go to. That was very puzzling to me as to how that could be the case in America. Now, the laws that prohibited Black children from going to the schools where white children went to school, and we're going to go through some terminology here, were called de jure. They were de jure discriminatory. And that means discriminatory as a matter of law. And they were also facially discriminatory. They were discriminatory on their face. They said Black children could not go to school with white children. And this was in public school. We're not talking about private school here. There was one case out of Mississippi, I believe it's called Gangnam. It's a little girl named Martha. She was of Chinese American or Asian American ancestry. And so her parents wanted her to go to the white school because it was much better equipped. And she went for a day or so, and then they had her removed from the school. So her parents brought suit. And the court basically said, the parents said, we're not Black, so she should be able to go to the white school. But the court said, you're not white either. So therefore your daughter could not go, their daughter could not go to the white school that was better funded with taxpayer dollars. Now, point 7, we know that Brown versus Board of Education, Brown 1, Brown 2 came along in 1954. Brown 1 was decided, and then Brown 2 dealing with the remedies. But there was, even though the court ruled in these cases, Earl Warren was the Chief Justice at that time, considered the most liberal court in terms of under his leadership in American history. But even though the court ruled and said that separate and equal, that segregation in K-12 public schools was unconstitutional, there was still what was called massive resistance. And I put all these words down in the box, text box below. There was massive resistance to the desegregation of public schools. So many people did not want their white children to go to school with Black children like me. So what is so fascinating is that even though Brown was decided before I was born, Look, I'm old, but I was not born in 1954. I did not attend my first class with white classmates until 1970, when the state of Mississippi decided to, well, to comply some more with the holding of Brown versus Board of Education. And you may say, well, what happened? Well, why are the schools not desegregated today? Well, there was a lot of massive resistance to Brown, and a term that is frequently used is called white flight, as whites moved into private schools and also moved out of certain neighborhoods, and then the schools became segregated again. But that segregation was not de jure as a matter of law. That segregation was de facto as a matter of fact. And the court has been hesitant to address that type of segregation as a matter of fact. And also the court has been hesitant to allow school districts to deal with the de facto segregation that continues to exist. Let me give you an example. When I went to high school, I attended, this was after Mississippi complied with Brown. I went to high school, and the high school I attended, I'm going to say it was very predominantly white. It was. And I was the first Black valedictorian in my high school class. I worked very hard. My family was very proud. Now, the same high school that I attended that was very predominantly white, today it is very predominantly Black. So there continues to be segregation, but the court says this is not de jure as a matter of law. This is de facto as a matter of fact, and the court is more hesitant to allow remedies in that regard, at least the majority of the court. Now, what about all this unequal treatment as a matter of race? You may say, isn't there something called the Equal Protection Clause? There is. The Equal Protection Clause is in the 14th Amendment, applies to states, and it applies through the Due Process Clause in the 5th Amendment for the federal government. And I talk about that more in the longer clip. The court says that when there is state action and when the government is treating similarly situated individuals unequally based on race, that generally government must satisfy the highest level of review. Remember the high level of strict scrutiny. Government must have a compelling governmental interest, and the unequal treatment must be narrowly tailored to that interest. And sometimes there are governmental measures that actually satisfy strict scrutiny, and we'll talk about that some in a later clip. Okay, I'm trying to see where my notes are. So racially unequal treatment continues today, but it is likely, often, frequently, not on the face, right? It's not, a law may appear facially valid, and these terms are all at the bottom in the text box. It may appear facially valid, but it may appear to be facially neutral, not favoring one race over the other, but it may have a discriminatory purpose or discriminatory intent or discriminatory in its application or discriminatory in the effect, a disparate effect. And I mentioned some of the cases in the text box you may want to take a look at where that type of effect may be causing unequal treatment related to race. But the court is more hesitant to address racial disparities that are not on the face, right? That are not a matter of law. And the cases I mentioned in the text box gives you a little information on that. And of course, the longer video. Now, Congress does have authority that, even though the court may say there's no constitutional violation, Congress does have authority to bring about more equality as related to race. But sometimes when Congress attempts to act, the court may come back and say, Congress, you went too far, right? And I've commented on that below too, in terms of Shelby County versus Holder, a case dealing with voting rights, and what the court did that had a huge impact on voting rights for people who are not white. In Shelby County versus Holder, the court struck down a portion of the Voting Rights Act from 1965. And I give you the name of the case so you can read that and you can check me. If you want to know more about this topic, I give you the names of the cases below. And I also give you my longer link. So my link, the link to my longer video, and also the name of a book. You know, my students probably don't have time to do extra reading. They're so busy reading these cases. But for the rest of you, there's a book that a group of several law professors edited called Children of A Generation Remembers Brown. I call it Children of the Brown Generation. And my story appears in that book, and I get to name the book below. And the title of my story was The Loss of Innocence, you know, the loss of racial innocence. You know, I still believe in the preamble of the Constitution. We, the people, in order to establish justice, learning, enlightenment, and freedom. Those are key. So in our pathway to more justice, or at least a taste of justice. Subscribe and sign up for notifications. You don't want to miss a thing.